All right, we are back in Senate Judiciary. It's March 27th. We're taking up page 118, and we have Julio Thompson from the AG's office with us.
Hi, good morning, Senators. My name again is Julio Thompson. I'm an Assistant Attorney General and Co-Director of the Civil Rights Unit. Our principal responsibilities in that unit are to enforce a variety of anti-discrimination laws in Vermont, including laws relating to fair employment practices, non-discrimination in employment. Civil Rights Unit also has enforcement authority under the civil provisions of the Hate Motivated Crimes Act. We have a criminal division, which, like 14 states attorneys, can enforce alleged hate crimes in criminal court. I don't think in the brief time that Todd Delos from our office previously testified, there is a civil half to the hate crimes law. So even if a case does not go to criminal court, there are civil remedies that are available to the victims or survivors of a hate crime. And the law gives the Attorney General specific authority to seek an injunction against the offender, which might be in order to either desist in that activity or keep them away from the location for a specified period of time, subject to court approval. The Office of the Attorney General also has authority to seek state penalties. Violation of a hate crimes injunction is itself a crime, as it is the violation of other orders or relief from abuse orders and so forth under state law. Vermont law also calls for the Attorney General's office to develop and deliver the hate crimes curriculum for the Vermont Police Academy. So twice a year, you'll find me over at the Police Academy teaching new officers or just officers to be how the hate crimes work at the state and federal level, how they interconnect. That covers a number of related subjects, including First Amendment or equal protection issues. And then our office 2 years ago provided statewide training for all law enforcement. So every officer from first day officer to police chiefs and sheriffs were part of a refresher training that we delivered statewide in person. So this area is a familiar topic of mine, and some of the issues that are related in terms of how you prove a hate crimes case are really drawn from civil rights litigation that's been on for more than half a century. And so I think Todd thought it would be helpful to the committee given questions or wanted me to walk you through what the existing law says and what the change was making. So to start with, the existing law, the hate crimes law, which starts at 13 VSA 1455, was first enacted in 1989. The original enacting statute, which is in actually 13 VSA 1454, the statement of purpose for legislature said that it's the right of every person to enjoy the public peace and tranquility and security, and that wrongful activities motivated by hatred towards particular classes of persons or classes or groups of persons invade that protection. And therefore, it's the intent of this law to cover that without infringing upon the rights protected under the Constitution. The enacting statute was really talking about the overall purpose was crimes or wrongs that are motivated by hatred towards individuals or groups of people. The rest of the statute that's been in effect since that time was really focused on the word victim. In the original version of the law, which has since been amended by this legislature just a few years ago, the element of proof was that you still had to show a crime or an attempted crime. And under the original law, you had to show it was maliciously motivated by bias towards the victim of the crime. Now it just says bias towards the crime because malice tends to be a higher standard of proof that you often find in fraud cases and punitive damage cases. And it was focused on the victim because at the time when these laws were enacted, paradigm example they were thinking were crimes against individuals or homeowners. So someone's assaulted, so someone lives in a house, and their house is vandalized. And over the years, as we've been enforcing this law, or as we've been involved in it in the civil rights side, what we're looking for are usually to find out those cases which are not suitable for criminal court. So a case could be pending in Rutland County, for example, alleged hate crime, could involve a juvenile offender, for example. And it may be a gray area case, or that they don't think they have enough proof to show one or more outlet, let's say the bias element beyond a reasonable doubt. The existing law says, even if there's a decision not to take a criminal case, we, or indeed the victims, the survivors of the offense, could go to civil court and seek civil relief. Our role in the civil rights unit is when we have something that's covered by the law, that gives us authority to be involved in that conversation about what do we do with this problem. So you could have cases where someone vandalizes someone's car, a high school student vandalizes another high school student's car, and there's some racial or some bigoted epithet that's spray painted on the car. Often prosecutors are not really looking to put that juvenile into the system. A conviction of a hate crime can be lifelong stigmatizing. So our office, part of our job in the civil rights unit, is we're looking for a different path to resolve that. Obviously, in my example, someone's got a damaged car, someone's got to pay for that. And are there ways for the wrongdoer to acknowledge wrongdoing for people go on? Because these cases might involve classmates or neighbors, or sometimes even distant family members. And so that's really the role in the civil rights unit, is we're looking for that, the way of resolving it, either through reference or working with restorative justice professionals, or if necessary, going to civil court, either as a supplement to or alternative to criminal court. And periodically, we take feedback from law enforcement officials when we develop our curriculum. We find out how that law is working or if it's not working. And we've had various community fora. We've gone to different counties to talk with people about these laws. One, to let them know what the laws are, two, to tell them where they can report, and three, to find out what we can do or where the law falls short. And that includes taking typically feedback from state's attorney's offices, community members. We often have representatives or senators from those communities who are in the room. And over time, when we identify some shortcoming of the law, then we have conversations about it to see if there's some adjustments to be made to the law. H 118 is one of those kind of community, and I would say law enforcement, I would say it's like equal feedback from both sides. An adjustment to the law to address a class of crimes that are where there is evidence that it was motivated by bias, but the criminal act technically, the victim of the criminal act technically isn't the person that the hatred is directed at. The paradigm example would be someone who spray paints a swastika on a homeowner's house, knowing that the occupants are Jewish. The crime is the spray painting. That's unlawful mischief. It costs money to replace the door, repaint the house. That's the crime. And it may turn in that particular case that the family inside don't own the house. They rent the house. And so under Vermont existing law, the victim of the unlawful mischief is the owner, who might reside out of state, who the defendant may never have known and have any idea whether that person is Jewish or not. They were clearly wanting to intimidate the family inside. Under existing First Amendment law, depending on the circumstances, spraying a swastikas on someone's house or on their driveways, or something like that may cause a lot of fear, but it may not rise to the level where that act is itself a criminal threat. And in other states have found ways to address this through their hate crime laws. And so we've encountered over the years, in more recent years, a number of cases where there are criminal offenses that are committed on public property, like say defacing places of worship, schools, school buses. Many years ago, there was a police barracks. I think it was in Royalton that was defaced with symbols. Sometimes it's on the roads, sometimes it's street signs or bridges, where there's something, there's an unlawful event, and then there's some evidence to indicate that there's a biased motivation related to that. When we're talking about things like symbols, like the Nazi symbol, under these laws and under the Constitution, they're not being punished because we disagree with Nazi symbols. That's not the crime. But it can be used as evidence of intent behind the crime. And that's really what this law seeks to address, is to say that you would have a criminal act that is motivated by bias against another person or a group of persons perceived membership in a protected category. So to apply this law in practice, in Vermont and in New England and around the country, you have cases where students are going to go visit another student's high school to go play basketball. And one team has a number of Black or athletes who are non-white. And they play the game and then they come out and they find the school bus has racial slurs written on it, which causes a lot of disruption in some parts of the country. It can lead to vigilantism if there's not perceived to be an appropriate kind of legal response to that. But in those cases, under existing law, that couldn't be considered a hate crime. There would be nothing we could do to intervene on the civil side to try to find an answer to that under the hate crimes law, because the students who were targets don't own the bus. So they're not victims. The school district is a victim, and the school, government entities don't have race, they don't have national origin, sexual orientations, and so forth. So really, this law is addressed to try to cover those sorts of cases where there's, again, clearly hate motivation, it's always a matter of proof, but you have cases where there's a hate motivation that's evident, and the community often is surprised when they come to us or law enforcement and learn that the hate crimes law doesn't cover that. And we think that fixing this gap will not only help us to address those sort of things, but also build confidence in the government officials who respond to it, so they don't believe we're not addressing it because we don't care.
Senator Proof. But thanks very much, Julio. I'm looking at H118 and I'm just trying to clarify in my own mind what it seems like, unless I'm reading it wrong, that both things are kind of technical corrections. Is that right? So in other words, the changes are, instead of victims, we're saying another persons or different persons. And then apparently there's kind of a glitch in the grammar of the rest of that sentence. And so we're adding perceived membership in A, and that's pretty much it, right?
Well, I think it's a narrow change in the law, but I think it is substantive. And I think I think we view this as kind of an artificial and indeed could be an inadvertent barrier that was placed in the law when it was enacted.
But I'm failing to see the substantive change. And
well, the first question, in order to have a hate crime under this statute, you have to have a crime. And in order to have a crime, you have to identify, is there a victim associated with the crime? So to use a spray paint example, you spray paint a school bus. The crime is unlawful mischief. It is damaging property, regardless of what's spray painted on the bus, or someone breaks out a window. So who's the victim in that case? It's not the student, because the student doesn't have to pay for the property damage. The school district does. And so under existing law, we are restrained. We could not treat that case as a hate crimes case because who's the victim of the vandalism? Technically, it's the school district, which doesn't have a race. It's not the target, because the law here went by tying the hate motivation to the victim. You are artificially restricting the intended scope of the statute, we think, which is that there's wrongful conduct directed because of bias against individuals or groups of individuals. So it does enlarge the number of hate motivated, and we think harmful conduct that's out there. And so I think there will be a change in terms of the scope of the law. It's just, it is technical in the sense that, again, you're changing just a few words, but that actually has a substantive.
And I think that's what you're saying. So there are there are essentially two offenses. There's a property crime and then there's the enhanced hate crime motivation. And so you have two victims, you know?
The hate crime, in order to have a hate crime, you still have to show the motivation is against the victim. And so if your victim is the school district, you can never prove a hate motivation towards a non-human entity.
Yeah.
Or it could be the absent landlord example, where you have an African-American family in a house rented by a white person, your perpetrator is white. The victim of the vandalism, because they're the one who's going to have to pay for it under the lease, is the landlord who's white. So there's not hate motivation against a white absent landlord. And so you can't prove a hate crime.
But still in all, we're talking about the crime being against the owner of the house if it's rented.
Right.
And then, so what this is saying is that the renter is another group of persons.
Right.
But it seems like we're kind of pretending like they're two different incidents.
I think it's an artificial distinction
Yeah.
that exists in the law. And to use the homeowner example, you could have vandalism on two neighboring homes. And whether something is a hate crime or not, the identical set of facts, it's a Jewish family in each, identical swastikas, identical motivation by the perpetrator, and whether one could be treated as a hate crime or not might turn on the condition of what's on the lease. One person, they own the home, and so they have, as the owner of the home, they have to pay the damages. So technically they're the crime victim. The other ones, they're lessee, they're leasing the home. And so there's not a hate crime. And so we believe that is an artificial and likely unintended effect of the law. And so we just want to lift that little linguistic barrier to be able to cover cases where people are being.
And I'm totally fine with it. And I'm totally fine with cleaning up the grammar of that sentence because it's hard. I reported this on the floor. It's hard for me to believe that I had to check the statute. I can't believe I let it read actual or perceived protected category show the subject by the victim's actual or perceived protected category. That is just clunky. So putting membership in A makes it smooth grammatically. So that's on me for the grammar of it.
We encounter these things from time to time. That I think in 2022, maybe 2021, the last amendment, again, it's somewhat technical. We'll learn part because it was just a recognition that people don't do things for just one reason. That's very rare.
Yeah.
And so a lot of states, which enacted these in the late 1980s, and again, had a number of cases, that they were actually trying to apply them to. And that was a very meaningful and I think realistic change to the law.
Mm-hmm.
And that malicious motivation was also, I think, an artificial barrier.
Mm-hmm.
So my question, the thing that I'm still grappling with, and I feel like I have to provide a disclaimer at the beginning that I call for strengthening this statute, but if I'm looking at a hypothetical in which, let's say somebody spray paints, outside of the National Guard base, and they're using whatever colorful language saying, I hate the U.S. military, or for whatever reason, and so they can get charged for unlawful mischief, and there's a protected category of the National Guard in there, and because of this enhancement, they could face an increase in the amount of jail time or the fine. And so can you explain to me how it's not a content-based or viewpoint-based regulation on speech to impose this on somebody if they're spray painting their opinion about the military?
Sure, because the predicate, the basis of the offense is a criminal act. So when we're talking about speech and we're talking about hate crimes, sometimes we say with the students, when you're talking where you've got evidence that you can prosecute a crime, in some sense, free speech is already your rearview mirror, because there are types of speech that are protected and are not. And so, assaulting someone and then writing as part of the assault and writing it, drawing a swastika on the person is not protected speech, even though the person wants to express an idea. That's not protected expression. Similarly, vandalism is not, if something is unlawful, graffiti, that's not legally protected speech either, even though that's what the person might want to do. There are any number of criminal acts that could be viewed to express an idea. There are people who blow up buildings because they want to, government buildings, because that may be part of their campaign just for like political overthrow. That's also not protected conduct. So, the Supreme Court's already looked at this case. It's a famous case, 1993 case called Wisconsin versus Mitchell, that involved a criminal assault of someone, where there was evidence from the co-defendants that they wanted to select someone of a particular race and go assault them. And part of the challenge, part of the defense in that case was the government is punishing people for their thoughts, because one of the statements had said, let's go find, protect person of this particular race and go harm them. And the argument was, well, that you're punishing them for their speech or their internal thoughts, and that's violative of the First Amendment. And the Supreme Court came back and said, we look at what's in people's head, what their statements are all the time in law. We look at, for example, in antitrust law, people say, hey, let's set the price of gasoline to be $3.50. That's speech. It's also a criminal act. It's a criminal conspiracy, right? Your money or your life, stick them up. There's lots of speech that can be punishable because it could be evidence of a crime, including intent. Punitive damages in any civil case of any sort. In order to seek punitive damages, you have to show someone acted maliciously, which the court defines as someone having, quote, bad intent, bad motives. And the way you prove that is that speech might be a way of showing that bad intent. Someone, takes someone to court and they type in social media, yeah, I'm doing this because I really want to drive this person out of our neighborhood. Civil rights law, denying signs that say, the old signs, Irish need not apply, or you have, unreasonable advertising that's intended to screen out certain applicants. That's all speech that can be used as evidence of unlawful intent, which the Supreme Court said in the Mitchell case, societies can decide that some conduct is worse than others, that it has more harm. And in the hate crimes context, singling a person out and committing a crime against them because of who they are has a multiplier effect on the whole community. It's a threat for the whole community. They feel that fear because they may share some of the same characteristics. So in your National Guard example, if the crime is, violation of the sidewalk, under existing law, if that's a public sidewalk and it's a statement that's not a criminal threat, that could never fall under the hate crimes law. It never could. The statement itself is not punished because they made the statement. It's evidence of the intent, and that's what's being punished. We do this every day in employment law when we deal with this, where someone doesn't get a promotion. Denying someone a promotion is not inherently unlawful. Denying someone a promotion because you want instead to promote a family member, so you want to engage in nepotism, it's a terrible thing. It's not unlawful if that's the reason you're doing it. But if you do it because you don't like the color or the religion or the national origin of the person who asked for a promotion, and they're otherwise qualified, that's something we've long punished under federal and state law. So it is and how would we prove that case? Well, someone might make a statement on a request. We rarely get evidence this direct, but just indulge me for a second. Someone just puts on the request, yeah, I'm not really comfortable with them because of blank, and you can put in whatever the bias is. That's speech, and that's evidence that's used to prove motivation. That happens all the time. one's not being punished for their general views about the world. It's speech that is shoved to, it's tied directly to the conduct, which is the denial of the promotion. That's the act. And so there's nothing, Supreme Court in its Mitchell case, and there's nothing surprised about that. We couldn't have civil rights laws if we didn't look at, other types of circumstantial evidence to show, motivation that that a community or legal system thinks is, inherently more evil than others.
Oh, very helpful. Thank you. Did you have additional testimony, or we kind of ended up just going into a Q&A, but did you have additional thoughts you wanted to share?
I don't think so. I guess what I would say is just about the need for this. We've encountered plenty of cases in recent years where there are acts that we think would be hate under this bill would be hate crimes that can't be treated that way because of that victim requirement. Particularly organizations like in 2022, the Pride Center had someone throw rocks through their window. They've had other property that's been vandalized. That can't be treated as a hate crime or treated as a hate crime civilly or criminally if they rent the building. And then so what happens in real time in those communities, people go to their local prosecutors, they go to law enforcement, they say, if this case is going to get charged or it's being investigated as a hate crime, and they say, no, it's not. And then that, the community doesn't understand that. It seems very arbitrary. And our experience has been that tends to fall most heavily on local law enforcement who suffer the perception that they're not pursuing a hate crime because they don't treat it seriously enough, where it is in fact an artificial barrier in the law. And so we think that changing this will not only expand the number of cases we can address, but we think will help build community confidence, because we've had prosecutors come to us saying, this thing happened, it happened to a bridge. The bridge is owned by the state of Vermont. I don't see how this, and it's clearly hate motivated, and the community is frightened or up in arms. But as far as I can see, we can't treat it as a hate crime. Is that right? And we say, yeah, that's right. And we have difficult conversations with community members who are frankly surprised by the limitations in the law. The last thing I would say is that there are other states that have taken this approach, that have had this approach, that have had First Amendment challenges that they withstood. Illinois is one, Pennsylvania is one that I'm aware of. Delaware is another one where, again, it's bias against, or the crime is motivated by bias against another person or group of persons, even if they're not the technical victim of the crime. So I don't think it's anything radical. I think every case is going to be decided on its own merits about what sort of proof the prosecutor or our office has. That's true for all discrimination cases. It's true under the existing law. We'd like to remove artificial barriers so that we're able to address the full scope of harms that we think can occur out there. So I think that's it for what I think. And then,
Thank you. Committee, any questions or comments?
I walked in late, so I apologize for that.
Can Matt say anything? No, you're very great. Well, Julio, thank you. It was very helpful. Yeah. Don't have anything else? For today. Yeah. All right, we can adjourn.